And in a few moments, people will start logging in. Just stand by for a minute.
Okay.
Okay, we're live. This is Attorney Vincent Davis, and the show is Meet the CPS Experts. Tonight, we have an expert. His name is Walter, and Walter works for my office as an attorney representing people in CPS matters. Hey, Walter, how are you?
I'm doing well. Thank you very much for inviting me to the show, Mr. Davis.
No problem. Tell the viewers at least a little bit of something about your background and what you do.
Okay. So, hi, my name is Walter, and I am a current juvenile dependency lawyer at the law office of Vincent W. Davis and Associates. Prior to joining the wonderful firm, I was a court-appointed attorney who has dealt with several hundreds of cases as it relates to CPS. So I'm very well versed on that subject, as well as different interactions and type of ways in getting comfortable in front of the court.
Tell me what type of interesting cases do you have these days while working at the office?
Well, I have a few interesting cases, substance abuse cases, as well as domestic violence cases, particularly as it relates to showing a particular argument to the court as it relates to making reasonable efforts. So it's interesting. I have one client that has done, a great job in the case doing substance abuse program, but now is just being able to convey to the court that the client has been making substantial progress in the case plan. So that's pretty interesting. I'm kind of excited on how that turns out. I think it's going to be a winning case. We'll see.
Very good. For those viewers, if you have any questions, go ahead and post them on the comments section, and Walter and I will be answering questions this evening that you might have regarding your case. Walter, what do you think about what's the hardest thing that you find that you have to overcome in representing parents in these CPS cases?
Well, the hardest thing, based on my experience, is being able to have the CPS particularly be somewhat more collaborative and actually showing and doing their own due diligence. Oftentimes in cases, I have a lot of parents doing what they need to do, showing cooperation, but the social worker and or caseworker is not doing their part and their end of the bargain in trying to, for example, provide proper visitation, make the referrals on time, so then they can properly reunify with their kids in the X amount of time frame. And it's quite frustrating because now we have to do an additional effort in trying to fix and correct the problem that the social worker should have potentially avoided, but now we have to come in there to make sure they're doing their job. And it's quite frustrating just trying to have these social workers do their jobs when all they have to do is, reach out to the clients on time and also provide them with the proper visitation when need be, because these parents are dealing with a lot, and it is traumatizing not being able to see your kids for quite some times.
When you are dealing with social workers on different types of cases, do you think social workers go out of their way to sometimes retaliate against parents? Or is it they are just too busy? Or is it a combination of a lot of different things?
I believe, based on my experience, it's a combination of a lot of things, but I think it is most likely both. Sometimes they are busy, understaffed, but also they are sometimes vindictive towards the client. And it's not entirely fair dealing with these situations when they should be doing their job, even if they are, understaffed. That should not be an excuse to do their job on time and ensuring that parents get the opportunity to do their visits on time and also make the proper referral, so then clients could actually get on the ball in terms of reunifying with their kids.
Walter, here's a question posted by Bella on one of the Facebook pages. She says, or she asks, how can I compel my active juvenile dependency attorney to release opposing parties' evidence to me? I'd like to be able to defend myself, but I haven't had an opportunity to review in order to refute or defend myself. What is your answer to that? How can she compel her attorney to do something?
Well, for one, there are professional responsibility rules set forth in California as it relates to particular evidence relating to a case. You do have the right to request those documents, and typically you have to make the proper approach to them and request it. And if it gets to the extreme where they're preventing the documentation being released to you, then you may need to probably take that to the state bar and see if they could actually make the attempt to get those documents.
All right. I would have to agree. What I would do as a first step is I would email and call the attorney and say, hey, I'd like you to turn over the copies of the documents to me so that I can help prepare the case. Bell, I wouldn't advise you to represent yourself. It's more sophisticated, more complicated than you might imagine. Walter, what do you think about people representing themselves?
The best, advice, and it's when dealing with juvenile dependency issues, it's very specialized, it's very, very focused, and a lot of attorneys in the courthouses practicing are skilled and have the proper experience with that. And having, I guess, a parent representing themselves can be very complicated. It's very, very draining. There's a lot of legal procedures that needs to be followed, and there are a lot of things to consider that attorneys, particularly attorneys practicing juvenile dependency, has. So it's not highly recommended not to do so. It's usually best to try to reach out to an attorney, but typically a juvenile dependency lawyer that understands these type of cases.
Walter, a lot of people that I talk to are focused on the black letter law of DCFS or CPS cases. And I tell a lot of people that sometimes, the law is not the most important thing in the case. And that shocks a lot of people, because not only is there the substantive black letter law in California, it's the Welfare and Institutions Code, but it's also the evidence code, the evidentiary laws in cases. It's also the Code of Civil Procedure, and the cases and statutes that interpret how things can be done in a courtroom. So it's a mix of a lot of things. And then I tell people, the most important part of your case is your story. It's the story, the facts of the case. And, over the years, in December, I think it'll be 35 years for me. I would have to say that most cases are won and lost outside of the courtroom. Because outside of the courtroom, you do your investigation, you do your preparation, you speak to the witnesses, or you speak to your client. If that doesn't take place, you're probably behind the 8 ball. So you want to make sure that you speak to your attorney and you come up with some type of strategy. Now, let's be honest. Sometimes cases are in such a position that it's very difficult to pull them out of the hole. And, a lot of people come to me and they say, I was talking to a couple today and they said, we want to hire you, but we want one thing. We want a guarantee. And I said, I can't give you a guarantee. And they said, well, why not? We're going to pay you a lot of money. You should be able to guarantee a result. And, the first thing I said was, look, it's a crime, it's a felony in California. I think, as in most states, for a lawyer to guarantee a result. Just can't do it. And I'm not trying to catch a criminal case. The second thing is, I had probably talked to them 45 minutes. Their case was over a year old. I said, in 45 minutes, you can't tell me everything that I need to know about this case to give you my opinion about it. I just can't. It'd be like a doctor giving you an operation without reviewing the chart. I said, I have to review the file. There are some things that I'm asking you right now that you don't know the answer to. So how can I tell you what the result is going to be? I just can't. I said, I have a line that I use. I say, hey, you know what? If Johnny Cochran were alive, he couldn't give you a guarantee. One of the greatest lawyers of all time in the world, in our country, he can't guarantee anything, or he couldn't when he was alive. So it's very difficult. People, I don't think really understand that. And then you have forces working against you. You have the social worker and the social worker's attorney, the county council. And in a lot of cases, the minors council is working against you, right? And then you might have another parent's attorney that's working against you. So there's a lot of factors. I know you want to get the best representation. I know you want that things are going to work well or work out well for you and you're going to get these children back. But no lawyer in the world can guarantee you that certain result will occur. What do you think about that, Walter?
Mr. Davis, I am on board. I have something to add on that too, is that even though the result may not be guaranteed, what I often say to my clients is that I can guarantee you that I will work hard and to my best of my ability to make sure that you get the best representation there. So that's one thing I can guarantee. But in terms of results, I totally agree. You cannot guarantee those results because there's a lot of factors that comes into play in deciding whether or not a judge goes from one ruling or another ruling. So I totally agree with that.
Okay, here's Stacy. She's watching us on our YouTube channel, CPS Strategy Consultant. She says, is it possible to reschedule a temporary custody hearing on my own behalf after my attorney recommended I vacate? Well, Stacey, I was following you there for a minute, but after the comma, after my attorney recommended I vacate, I don't understand that part of the question. So if you want to further clarify in the comment, go ahead. But is it possible to reschedule a temporary custody hearing? It depends on what type of hearing it is. If it's the detention hearing, the only thing that you can do in California under the code is schedule a rehearing, or you can try to take a writ to have it overturned at an appellate level. What do you think, Walter?
Yes. So when it comes to, with that question, is it possible to reschedule temporary custody hearing? There are a lot of things that come to my mind. First off, whether or not that's the initial / detention hearing, or whether or not we're talking about after disposition in terms of placement, particularly when it comes to the 6-month review hearing, 12-month review hearing, and so on and so forth. It's kind of difficult in trying to answer that question, but it's usually best to. There are some motions that attorneys can file, and particularly when it comes to the 6-month review hearing, in terms of requesting for placement or requesting for a special hearing, to try to have kids to potentially be returned early, but that's the only things I come up with in terms of that question.
Okay, very good, fair enough. And Stacy, if you want to further clarify that question, be happy to give you a clarifying answer. Okay, here's another question from Jesse. Jesse, how can I get an attorney to bring acting director I have, Missouri Department of Social Services, Jennifer, to the federal courts for her abuse of power and conflict of interest in adopting my twin daughters while demonstrating the behavior that has been in our most recent news headlines? Jesse, I'm not sure what recent news headlines you're referring to, but if you want to sue somebody, and you want to go to federal court, what I would do is, first of all, I'd find a civil rights attorney that has experience in suing social workers. Because if you're in California, where I am and where Walter is, social workers enjoy something called qualified immunity. I was talking to someone the other day. You just can't. And what they told me about the case, this is what they told me. They told me all of the ways the social worker was lazy and didn't do this and didn't do that. And, at the end of the conversation, I said, social workers enjoy immunity, qualified immunity. I said, you're going to have to prove something malicious here in California. If you prove negligence, you're not going to win on a civil rights claim. So you got to have more than mere negligence. And although she didn't like that answer, she understood it. And then at the end of the conversation, I said, well, do you believe that your social worker did anything malicious, or was it just negligent? And she said it was probably just negligence. She talked about her IQ and the social worker being lazy, but she couldn't say honestly that the social worker did anything maliciously to her. And by maliciously, I mean, set out to really try to injure her in her case. So you can sue a social worker, but that doesn't mean you're going to win. And what the question you should ask is, if I sue the social worker, is it likely that I'll win? Not, can I sue, right? Anybody can sue anybody basically in this country and in California. Here is a question from Carissa. All I can say is, when you're dealing with Child Protective Services, is hire a private attorney immediately. Do not trust a court-appointed attorney. And then Carissa goes on to say, it's strategy that the attorneys use. They need a good Child Protective Services attorney that knows how do use strategy. Okay. I think I get your point, Carissa. One of the benefits, first of all, let me say this. And a lot of people are going to say, Davis is crazy. I know a lot of court-appointed attorneys that are very good attorneys. I was a court-appointed attorney maybe 20 years ago, 25 years ago. The problem becomes court-appointed attorneys have a lot of cases. So, for example, Walter, first me, when I was a court-appointed attorney, when I left, I had about 400 and maybe 20 cases, 25 cases. Now, that's a lot of cases. When you left your court-appointed position, Walter, how many cases did you have?
I had close to 200 cases.
Right.
And it was increasing.
So that's a lot of cases. There were several years ago, and I don't know if it was Georgia or Mississippi, someone brought a lawsuit alleging that that the court-appointed attorney had too many cases. And in this particular case, if I remember correctly, it was the court-appointed minors counsel. And I think a 3-judge panel, I think it was a federal court as well, ruled that in this particular county, in this particular state, that the court-appointed attorney couldn't have more than, what do you think the number was, Walter? Take a guess.
150.
65. Couldn't have more than 65 cases. And during this case, and the federal courts, the trial courts have the ability to publish decisions, right? And in written decision, they went through all the evidence of what it takes to properly represent somebody in a CPS case. And it takes time, right? You can't have 400 clients and do a spectacular job.
Mm-mm.
It's just not physically possible, right? So you may be a great lawyer, but if you have 400 cases, somebody somewhere something's going to happen that's not going to be beneficial. I've told that story many times before, Walter. You may not know this, but you know what caused me to leave the panel as a court-appointed attorney?
No, what was it?
One day I was walking in court, down the hallway in Los Angeles County in the Edmund D. Edelman's building. And the court I was going to, there was a big waiting room outside for many different courts. A lot of people, about 8:25 in the morning, court's about to start. And I look over and I see one of my clients. And I'm thinking, what is she doing here? And then I thought, well, maybe she just came to court to talk to me, right? Maybe she's tried to call me. Maybe she wasn't able to get in touch with me, or I didn't call her back. And she came up to court to talk to me. Okay, cool. I'll talk to her. But I didn't say anything. I kind of waved at her, right? I went in the courtroom. And in this particular courtroom, the judge was kind of old fashioned. He used to do what's called a calendar call, but he used to bring everybody in, right? Have you ever seen that done?
No.
Right. This is real old school. So when the old school judges, they bring the people in the courtroom, and then they go through the calendar with the attorneys and with the people. They have to stand up and say, here, here, here. So when they called in all the cases for that morning, she came in. And I'm thinking, what is she doing coming in? And I'm kind of motioning to her like to wait outside. And she's like looking at me like, what are you talking about? So she came in and she sat down. About right at the beginning, somewhere like number 3 or 4 or something like that, the judge calls her case. And she stands up here. I'm like, I didn't have this case on calendar. And the judge looks at me and says, hey, Mr. Davis, are you ready to proceed? And of course, I say no, ask for second call, right? So at the break, after the calendar call, the judge always took a break. So after the break, I went up to the clerk and grabbed the file, and I'm looking at it. And I look at the last minute order, and the last minute order says it's there today for a contested, they used to call it a PPH, permanent planning hearing. Now it's called a 366.21F hearing. That's how long ago this was.
Oh.
So it was like the contested last hearing for the woman to get her children back. And they didn't have 2-6 hearings back then. All right. 366.26 hearings or something completely, new, since I think maybe the 90s or maybe the 2000s. I forget when they passed that law. It was when Clinton was president. He and Hillary passed this law to speed up the adoptions process. So in the old days, if you lost the permanency planning hearing, you could be referred to a second lawsuit, which was called a 232 action, Civil Code 232, where they would actually bring a separate case with a different judge to try to terminate your parental rights. And by the way, it wasn't easy to do. You know how they, terminate your rights like that at a 2-6 hearing these days?
Yeah.
It wasn't like that. It wasn't like that. So, here she was for that hearing. And when I figured out that she was going to lose her children because I did not know the case was on calendar, I asked for a conference and I requested a continuance. Judge says, no, I'm not giving you a continuance. I said, well, I miscalendared. I didn't have it on calendar today. And now this lady had 5 kids. They're like 11 and under.
Mm-hmm.
She's a single mom. And I had talked to her several times throughout the 6-month period because this was a contested, 12-month hearing, basically called it a PPH hearing. And she had turned her life around. I mean, really turned her life around. She had done all her drug testing, done all her drug program, did the parenting, did the individual counseling, did the domestic violence counseling, and she was raring to go. Now, there was a big problem on the case. The social worker didn't like her at all. So the report that we were working on, recommended, not to return to the children home. So here it was, me or this lady getting her 5 kids back. So I think the judge knew that I was going to admit incompetent assistance of counsel, right? IAC, because I didn't have it, calendared. I didn't have a file. I didn't subpoena any witnesses. And so when he finally called the case, the judge says to me, Mr. Davis, I understand you have a motion that you want to make. And I said, yes, I do, Your Honor. Motion to continue. I didn't have the case on calendar. It was my mistake, blah, 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 blah. And minors counsel and county counsel, they go ballistic. No continuance. Basically, they didn't say this, but it was like, F Davis, it's his fault. Too bad. And this lady's going to lose 5 kids. Just like that. Well, the judge decided in his infinite wisdom to give me a continuance. He continued it for about 10 days, something like that, 10 calendar days, not court days. And he tells me, he says, look, you better be ready at the next hearing, have all your witnesses, because you're not getting any more continuances. Okay, thank you very much. I come back, we have a trial. It's a knockdown, drag out, contested, PPH or contested 2-1F, what they call it now. And I won. That day, the lady goes home with her kids. I don't know how they did it in your county, but in Los Angeles County, they used to bring the kids in all the time, and they were downstairs in shelter care, and they'd be brought up to testify if needed. Now there's this big move that, no, we don't want to put kids on the stand, but that wasn't the way before, years ago, 2 decades ago. Anyway, so she wins her case. We win. She gets her kids back. She's happy. I'm like, oh my God, I dodged a bullet. The next day, I came to court and I quit. I can't do this anymore. I've got too many cases. Somebody's really going to lose their kids. And, I'm thinking, I can't live with myself. It's not like, I did the trial and I lost and I tried the best I could. It was like, okay, you're going to lose somebody's kids because you just screwed up. You had too many cases. And believe me, with 400 plus cases, you can drop a few cases. You could lose them. It's easy, right? Everything wasn't computerized back then, 20 years ago. It was the old pen and paper. There was nothing called Excel spreadsheet. Nothing called software to case manage your files. They didn't have any of that. It was you and a pen and a yellow pad. That was it. But that's why I left the panel as a court-appointed attorney. Because I knew something was going to happen if I continued to do this, with 400 cases. It's just, it's just humanly impossible. There's not enough time in the day. Look, you got to sleep 6 to 8 hours a day, right? Maybe spend time with your family. At the time I was married, had 2 little kids, right? And then I got 400 cases, right? I got to deal with the family, got to deal with the friends, got to deal with my mother, my mother-in-law. And then on top of that, I got 400 plus cases that I have to deal with. And they're all complicated cases. They're all important cases. We're talking about whether you're going to get your kids back. Think about that for a second. In a lot of these cases, you are going to be the only person that stands between your client getting the kids back or those kids being adopted by some strange foster parent. That's a hell of a responsibility.
Yeah, it is.
For a long time, when I first became a lawyer, I didn't want to do criminal law. You know why? Because I thought if I screwed up the case, some guy's going to jail. Right? It's talk about a burden on the shoulders.
Yeah, big burden.
Right. But, to most people, losing the kids is worse than going to jail. Because you're going to eventually get out of jail, right? Bail, parole, probation, something, right? If you lose your kids, you're not getting them back. How do you fix that? Can't. Realistically, you can't. I mean, is there, once in a while people call me, tell me, oh, Mr. Davis, my rights were terminated. It's been 3 years. What can we do to get them back? And I basically tell them nothing. There's a few Hail Mary passes you can throw, low probability of success. In some states, I don't know if you know this, Walter, in some states they're toying with the idea of even after termination, passing a law where you might be able to come back and get your kids later down the road if the stars align, in the right path.
That'd be a good one.
Yeah, I mean they're talking about it, but we're here present day, and we don't have that law, and I don't think they're talking about it in California, at least the legislature, right? So having a lot of cases as a court-appointed attorney sometimes can be detrimental. Sometimes. There are attorneys I've seen that can handle it. They don't do it for a lot of years because they get, burned out. It's tough situation. Okay, here is someone from our YouTube station. Kiuna says, everyone in my case is being poisoned, in my case by abusive sister, abusive ex-husband, CPS guardian ad litem, and children's attorney. And then she goes on to say, judges are biased. Now, Kiuna, I'm going to tell you something that's going to sound very harsh. Let's just assume everything you say is correct. Let's assume that. Now what? What are you going to do? What are you going to do? You're going to have to come up with a plan, Kiuna, if you want to get your children back. Accept the fact. Just assume that everyone is against you in the case. Now what? What are you going to do? You better sit down with an attorney. Your attorney, your private attorney, your court-appointed attorney, your maybe a consultation with a private attorney. A lot of attorneys give free consultations. A lot of them charge, a minimal amount. Right? Would you pay $50, $100 to talk to someone to try to learn how to get your children back? Talk to someone. Talk to more than someone. Talk to a lot of people, because your children, I bet, Kiuna, your children are the most important thing in life to you. So you got to come up and you got to have a plan. And then Kiuna published, yes, what he's saying is true. I feel that 100% of my case, they're trying to sabotage the case and not reunify. Okay, well, Kiuna, there's something that you can do. Come up with a plan. Walter, do you ever come across a case when you were a court-appointed attorney, or even an attorney with my office, where it just seems such an uphill battle for these parents? Do you ever come across that?
Yes, plenty of times. And
anything you tell the parent?
So in situations like this, like Kiana, particularly, I usually pose a question to the client. Are you fighting trying to figure out what's right, or are you trying to fight to get your kids back? And oftentimes I tell them that there's two types of battles. Okay, once we get your kid back and successfully reunify, then we could take it on to the next battle, and whether or not the process that they took was right. And that's goes to civil action against the department, social services, and so on and so forth.
That's a good point. I kind of tell people something similar. Do you want to win, or do you want to be right? Because in most cases, it's not the same thing. And I tell people, you came to me and you hired me, and you probably paid a lot of money. And if I tell you ABC and you decide to do XYZ, that's on you. I don't have a magic wand. I can't just wave my finger and boom, you got the kids back. I have to tell you a strategy, and I have to help me implement it. And by the way, like I was saying earlier in the show, the law is not the most important things. What did I say? The story and the facts. Whether you go to drug testing and test clean, that has nothing to do with the law.
Mm-hmm.
Whether you go to your individual or domestic violence counseling, that has nothing to do with the law. Whether you visit your children, that has nothing to do with the law. I was in, I was, maybe it was a 2-1F hearing. And one of the reasons why I watched this trial, I wasn't on the trial, but I watched it from the courtroom. One of the reasons the court made a decision not to give the children back was because the parent hadn't visited the child regularly. And the parent did have a reason for not doing it. And the reason was that the child was so torn up after a visit that they didn't want to see their child in such great distress, because the child apparently didn't want to separate from the parent. And then the parent on his or her own decides, well, I'm not going to visit. And of course, that's used against them. One of, or a part of, any reunification plan is regular and consistent visitation with the children. A lot of people don't think about that because it's the easiest thing to do. Like, oh, if I don't do that, they can't use it against me because it's just too easy to do. Oh, but they will. So make sure that you visit regularly. Okay, here's a question from Jessica. I have had issues with nail follicle test and have spoken to an expert, and my last test is not accurate due to prescriptions I've taken. We are going to court tomorrow to request the lab results, and it says isomer test. I've been sober for over a year and have passed 3 hair follicle tests. What's my next step? What do you think her next step is, Walter?
Well, the first thing is to determine what type of hearing it is. I assume this is particularly after the jurisdiction disposition hearing, and maybe coming up to a 6-month review hearing, or maybe after. And typically, if you have showed cooperation and you've done everything you need to do, set forth in the case plan outside of the hair follicle test, such as maybe parenting, individual counseling, and also doing a regular visitation and also being consistent, but also showing some meaningful effort in those visits, then the next step is to potentially try to request either authority to return your kids, and or request the kids to be ordered return. Authority essentially provides the social worker with the ability to return upon X, Y, and Z, versus an order is a judge saying that you must return the kids on that day. And there's a lot of things that must take place. One particular thing is your home must be assessed. That's the key thing. Oftentimes I figure a lot of parents are missing that part. A home needs to be assessed for safety and concerns. We are in a court regarding the safety and concern of the kids. And if the home is not safe, stable, and not roomy enough to some extent, then how can the home be proper? So that's one of the first step in terms of, they call it FM, family maintenance. So the next step is to try to request authority for family maintenance, or request for an order from the judge of family maintenance. That's essentially they return the children to your care, and the case is still open, but the kids are with you, increasing the chances of dismissing the case very, very soon.
I like that answer, Jessica. I wish you had contacted us before tonight if you have a court tomorrow, because one of the things I want to explain to you, most people call me and tell me the same thing about how the case started. The problem is that people are in different modules, different parts of the case. So I divided up the CPS case into about 6 different modules, right? And each module has a different law, a different set of tests, a different procedural requirements about how things are done. So don't think that if you come to me in module 4, that what would have been used or what would have been a winner at module 1 is going to work. I'll give you an easy example. Let's say you go to the disposition hearing, and you lose the disposition hearing, which means that the judge ruled against you and said that in California that you're a substantial danger to the child and there's no less restrictive alternative by clear and convincing evidence. Well, when you come back to the 6-month hearing, the social worker only has to prove by a preponderance of evidence that you're a risk to the child. And a lot of people, come to me like, okay, we should have won at the disposition. We didn't appeal, but there's no way they can prove that I'm a substantial danger to the child. And there's other alternatives, but that's not the test anymore. That's not the requirements. So make sure that you know what module you're in, and we can talk about that. Walter, last week I met with someone and they came in and they told me a story that took about an hour to tell. And I sat there and I listened to it patiently. And then I went up to the whiteboard, that we have in the conference room, and I drew 6 circles. I said, each one of these circles represents a different module under the statutory scheme of the Welfare and Institutions Code for dependent children. I said, now what you've told me a story about is good for module 1 and 2. I said, but you're in module 4. You haven't told me anything about module 4. Well, Mr. Davis, what's important in module 4? Well, what type of reunification plan was ordered? What's your progress in the reunification plan? Are you testing clean? Are you visiting? Did you do your parenting classes? Did you do your DV counseling? Those are the types of things that are important. And inevitably, the client says to me, but they screwed me in module 1 and 2. And this is the hardest thing that I have to tell people. Yes, I understand that they did. But unless you appealed and won the appeal, module 1 and 2, they're over. They're done with. It's okay if you want to talk about it and get it off your chest, but it's not going to help me in determining whether you can win a case at the 6-month review or at the 12-month review, at the 18-month review. And in some cases, did you know there was a 24-month review? Very rare.
Very rare.
And it's not going to help at all if you're at the 366.26 hearing, which is, in my mind, is just my opinion, one of the hardest hearings to win. Like if you're going to challenge a 2-6 recommendation to terminate your rights, you better have started 6 months before. Bonding study, 388, et cetera, et cetera, et cetera. All right. Jessica, I hope that we were able to give you some information, but if you can, what I would do is I would text or email or call my attorney tonight and say, hey man, what's the plan for tomorrow? Right? What's the strategy? All right. Here is Kiana again. Criminal court just approved with state that it's up to CPS or juvenile court to decide if I get visitation or not with my children, which is typical, while I haven't seen them in over 18 months due to bogus charges. Okay, Kiana, let's assume that you're in California. I don't know what state you're in. But if you haven't seen your kids in 18 months, there might be something wrong with the case, that you haven't seen your kids. And criminal courts generally, not all, it doesn't always happen like this, but criminal courts generally defer to the juvenile court about whether you have a visitation if you committed some type of crime that endangered or injured the children, right? I've had cases where my client has been accused of a horrendous crime and has ordered that my client cannot have visitation. I don't care what the juvenile court does, right? Criminal court has the ultimate authority. So what the criminal court has done in your case, Kiana, is typical, but that's not the issue. The issue is, why haven't you been able to see your kids? Without visitation over 18 months, you're not going to be able to see these kids, or you're not be able to get the kids back. Now, here's the other thing. Watch this, Walter. You see at the end of that question, she says, due to bogus charges. She's telling me right now about module 1 and 2. She ain't in module 1 and 2.
Mm-mm.
They were bogus charges, and we could talk all night about those charges being bogus. But it doesn't matter, because if she lost the trials, all right, and didn't appeal and went on appeal, those bogus charges are written in stone. They're like the 10 Commandments. They're in
Mhm.
granite. So, I don't mind talking about it and listening to it, but don't expect me to be able to tell you how to go back and fix that. Virtually impossible. Not totally, but
Mhm.
virtually impossible. The odds are going to be against you. Okay? So, Kiona, focus on the current module you're in and talk to your attorney and find out what you have to do and what you have to do to get the kids back. All right. Here's one of our viewers, Carissa. You're dealing with judges that really don't know or care, because I've been getting false reports from CPS the entire time. When you return these go in, sometimes I don't believe the judges are so aware. And then again, I believe some judges are very aware. Well, Carissa, here's the thing. Most people that become judges do it because they want to try to help people. And a lot of times when judges rule against you, you think they're not listening, but they are. And they just make a ruling against you. In our minds, sometimes we know what the truth is, but that doesn't mean the judge is going to agree with us. I've been involved in many cases that I should have won and didn't. I've won cases that I never should have won. You never know what a judge or jury is going to decide about you, about your client, about the story, about the law. There's a saying in the law, reasonable minds differ. And they do all the time in the courtroom. I appeared on a case this morning, Walter, and I just knew what the judge was going to do. I mean, I woke up this morning and, no problem. I know where the judge is going with this case. Not only did he not do what I thought he was going to do, he did something that I never even thought of that he was going to do. So, you just never know, what people are going to do, especially what judges. Judges have their own experiences, their own interpretation of the law, and they get to decide who's right and who's wrong. I mean, it's not a perfect system. I agree. But it's the only one we got. And it's probably the best ever developed in the world and throughout history of mankind. Can there be improvements? Most definitely. Most definitely. All right, let's go to Elvis. Elvis says, I've been told for the past 7 months that the time is up for my stepchildren and they will be adopted out. I fought for an adjournment and just got it. Next court date is in December. Well, that's great, Elvis. I wonder what your question is. If you have a question, Elvis, go ahead and post it. We'll try to get to it. All right, let me look at another question here. There's so many postings, I'm getting lost. All right, I'm completely lost. Oh, let's just find a new question. It's from Delia. For some reason, my post vanished. We'll repost it again, Delia. We'll try to get to it. Kiana, how do I change custody while bogus charges are indicated or indicted against me? Depending again on what module you're in, it will depend on what you can do. In California, we have something called a 388 petition. Walter, how would you describe the 388 petition?
Essentially, in a 388, there are two things that must be satisfied in order to have a hearing, and sometimes in having it granted. The first part is that there must be a changed circumstance from prior court order. So, for example, let's talk about, I believe we talked about visitation, and presumably, let's say the visitation was presumably, found detrimental for whatever reason, which was a prior court order. And things from after that court order has changed, saying that it is going to be better. That's the first part. The second part is that changed circumstance must be for the best interest of the child and or children. And essentially, the argument has to be made that if we were to give you or change the court order, how is it going to help the kids? How is it going to be beneficial? Is there going to be anything are we going to be in this reoccurring situation again? And essentially that 388 is a tool, is a very magical tool that allows attorneys acting on behalf of the client to change the prior order. It's amazing, particularly when it comes to, for example, a client not being provided with services. That client can essentially, after that court hearing or after that court has made a particular decision on that day, could do classes on its own. Client has to pay on its own, and also reach out to an attorney and file a 388 saying that things have changed. I'm no longer abusing drugs. I'm no longer in a domestic violence relationship. I've changed. I completed this. I'm better, and I know what it takes to reunify to the kids, and I know that I'm going to use proper coping mechanism and also things that's going to help make my kids better and put them in a better position in their life. So that's a 388. 388 gives attorneys and or parents the tools to change prior court orders and for the better of your case.
All right. So here's Elvis. Hey, Vince, do you know if I have to speak to my caseworker? Am I allowed to just not speak to her unless it's actually needed? Well, Elvis, I'm really hesitant to tell you what I really think, because in some cases it works, and in some cases the judges come down on me and my client. And here's what I think. The answer is no. You don't have to really talk to a caseworker, right? It's America. You don't have to talk to anybody. If you do talk to the social worker in many cases, on a scale of 1 to 10, 10 being the worst thing you can do in your case, it's a 10. Let's be real. Because your statements are going to be quoted in some report given to a judge. Sometimes they'll be taken out of context. Sometimes they'll be just incorrect. That's the danger of talking to a social worker. So what I do is I try to tell my clients, don't talk to the worker unless I'm present or one of my attorneys is present. Okay? However, there's a flip side to this, and I've seen this happen. If you don't talk to the social worker, it could be a 5 used against you. So the question becomes, what do you want, a 10 or a 5? You do the math. I always say I want a 5. I don't want a 10. But know that if you don't talk to the social worker, it will be used against you. And they'll make all types of implications about it. So when I tell people don't talk to social workers, there's another phrase. It's don't talk to the social worker, comma, unless I or one of my attorneys are there. And many times I'm misquoted by my clients, and of course social workers misquote me as well. They leave off the comma, that second phrase. So, Elvis, it depends on what state you're in as well. What I'm telling you is, for California law, other states may have a requirement that you must talk to the social worker. I'd be surprised if they did, but I can see that being a law. What about you, Walter? What do you think?
It, like you said, Mr. Davis, there are some ups and downs. One, communicating with the social worker and or caseworker. This is obviously referring to California. Can show that you're cooperative. Can show that you are serious about your case. That's one side of the argument. Other side of the argument is that that information can and oftentimes will be used against you in the court of law, particularly in juvenile dependency. And it's kind of hard. It's usually best to have an attorney there present with you when social worker is engaging in conversation with you, because you may not know what's important, you may not know what's relevant, but attorneys such as myself and Mr. Davis and other juvenile dependency lawyers, they likely know what's relevant, what's not relevant in terms of discussion.
All right. Here's our next question from SDQT. In California, are juvenile dependency TROs published publicly on a police website? Can a juvenile dependency TRO be extended for an indefinite period of time? Do you need to be served each and every time the TRO is extended? Okay, so the answer to the first question is, are they published publicly on a police website? I don't think there's a public website, but I do know if a TRO is issued in, it can be given to assist the police or entered into a system that if you are stopped, they will know if you have a restraining order issued against you. Second question, can a juvenile dependency TRO be extended for an indefinite period of time? The answer is no. By statute, it can only be extended a certain amount of days unless, now here's the big unless, you or your attorney agree that it can be extended. And what happens sometimes, Walter, is people call me up and they say, well, it's been extended for 5 months. And I ask them, did you ever agree to that? No. Did your attorney ever agree to that? Well, now that you mention it, yes. Right? So if your attorney or you agree to the extension, it could be indefinite, but most judges are going to say, look, at some point in time, hey, we got to have a permanent restraining order hearing or the TRO is going to die. Next question, do you need to be served each and every time the TRO is extended? The answer is yes, unless your attorney accepts service for you. That works sometimes, and sometimes you don't know the attorney has accepted it for you. Walter, it reminds me of something that happened many years ago. I had a mentor, kind of a mentor in juvenile dependency law, who was also a court-appointed attorney. And his name was Paul. And Paul used to always argue when the court ordered him to notify his client of the hearing. He said, no, Your Honor, I object. That creates a conflict between me and my client. And I asked him one day, I said, Paul, why do you say that? What's the conflict? Well, the conflict is if my client doesn't show up and I tell the judge that I did notify her to be there, they're going to use that against her and proceed without her, detrimental to her rights. Right? So that's one of the dangers of accepting service for your client, especially in these TRO situations. And I have seen it. I don't know about you, Walter. I see attorneys all the time. Yeah, I'll accept service or, I'll accept that for my client, not knowing what that could eventually lead to. Okay, here's Stacy. After the 72-hour TDM, the court petitioned the court for dependency, which was granted. My attorney requested the temporary custody hearing to be held within 5 days. Attorney recommended I vacate. Now, Stacy, I only know what you're talking about because people from other states have called and used those same terms. We don't use those terms in California, so I'm really not clear about the law or about the question. In California, what they have is a detention hearing, and I think that's what a lot of states call the temporary custody hearing, and Then we have what's called a jurisdictional hearing and a dispositional hearing. And at the jurisdictional hearing, the court has to decide whether, in California, it's by preponderance of evidence, whether the facts are true. And at the dispositional hearing, the court must decide that even if the facts are true, are you a substantial danger, and are there no less restrictive alternatives by clear and convincing evidence? Walter, I don't know if you know this, if you've ever thought about this, but it's hard to prove, at least theoretically, that a person is a substantial danger, not a danger, is a substantial danger to a child. You have to be one bad dude or gal to be a substantial danger to anyone, not a danger, not a danger, a substantial danger by clear and convincing evidence. And, you know, what I tell the attorneys in my office all the time is at these disposition hearings, always focus on the no less restrictive alternatives, because that's actually part of the statute. And it seems, I did a case in your old county, Walter, not too long ago, where it seems like the court didn't want to give that great weight, the no less restrictive alternatives, because I brought up evidence that there were alternatives to foster care placement. But of course, I'm not the judge, right? I don't make the decisions. I can only make the arguments and present the evidence. All right. So, Walter, we've run out of time, but I am going to take Nicole's question. It's a long one. She says, so I have multiple questions. However, I won't be able to get all of them answered in one show. You got that right, Nicole. However, my most important questions I will address. With that being said, my first question is, when you are appointed the caseworker for your family, and from the first meeting, that particular worker talks down to you, belittles you, and outright makes you feel inferior to them, and so I spoke to my attorney, who does nothing at all, even when it came down to DHS/CPS disobeying and completely disregarding, ellipses, nothing else after that. Okay, let me try to answer that question. In California, there is a section, I don't know if you know this, Walter, but there's a section in the Welfare and Institutions Code which permits you to make a motion to change social workers.
No, I didn't know that.
Yeah, you have to have the evidence, right? It's just not, I deem it so to be, right? You got to have evidence of something. And I would probably say, Nicole, your situation under California code would probably rise to that level. One of the things that people forget is that social workers are people just like us. And that means they have the same strengths and weaknesses. And sometimes, social workers, like police officers or anyone in power, they start tripping on the power, the power thing. And maybe they need to be put in check. Maybe you need to make that motion to get a new social worker. Maybe you need to file a complaint with the Department of Health and Human Services. Maybe you need to file that complaint with the United States Department of Justice Civil Rights Division. Maybe you need to file that complaint in Sacramento or in your capital with the Department of Social Services. I can assure you that if you make such a complaint and make such a motion, you will probably get a different social worker with a different attitude. Sometimes it's the same social worker, but, they've gone through, a talking to by probably a supervisor, right? Because they are public officials. And I think especially parents in this situation, Nicole, don't need to be belittled or demeaned. And does that happen? Yes, it does. I've heard it many, many times. Many times. I've had social workers try to belittle and demean me. Right? So if it's happening to me with their attorneys, right on the phone or right in person, I know it's happening to parents. Right? So social workers are people. And that means they do things that aren't cool sometimes, just like all of us.
Mhm.
All right, Nicole, I hope that answers your question. If anybody has any further questions, give us a call, 888-888-6582. Make an appointment to talk to me or Walter, and we'll see if we can help you out. Hey, Walter, I want to thank you for appearing tonight.
Thank you
I
very
hope I
much.
can invite you back in the future and have you answer some more questions with me on CPS Meet the Experts. Okay, Walter?
I'm more than
Everyone,
happy. Thank you.
everyone viewing, I want to remind you that tomorrow at 7 p.m. Pacific on these same social media channels, we have the new social media influencer, Erin Carranza, with her show, CPS Family Reunification Coaching and Motivation. So please look at us tomorrow night or turn us on tomorrow night and watch Erin's show. Erin had a special guest, and I can't remember who it was. I'm embarrassed to say, but she has a special guest appearing tomorrow that I think everyone is going to want to listen to. And also, I'm going to have a guest on that show as well. His name is Jeremy Pinon, and he is the director writer of a movie that premieres this Saturday at LA Live Regal Theaters in the film festival that's going on in Los Angeles at Live right now. And it's called Failure to Protect. And it's the story about 3 or 4 families going through the system, trying to get their children back. And it's quite eye-opening. And some of the expert interviews for this documentary were the guru of civil rights cases himself against social workers, Sean McMillan from San Diego, and a very prominent judge who is now retired, Michael Nash, and yours truly were interviewed for that movie. So please come out and support. And if you find the link or the website, you can actually buy a ticket to watch the movie live online. You don't have to physically be at the theater. But Walter, you're joining us with on Saturday night at the theater, aren't you?
Yes, I am.
Did you want 1 or 2 tickets?
2 will be fine.
Okay, because I'm going to email you 2 tickets.
Perfect.
All right, everyone. Thank you for watching, and we'll see you all tomorrow. Good night.
Yeah.